Herron versus Herron. And both sides, you are to know that you have 15 minutes each. And the appellant may reserve up to 5 minutes for rebuttal if you so choose. You just have to let me know so I can watch the clock. Also, we do have a monitor up there that gives your time, and you'll be able to count it down if you so choose, and be able to get a better understanding of what your time remaining is. And obviously, I will let you know when you're out of time. Okay? All right, we're ready to proceed.
Your Honor, I'm going to reserve 5 minutes for rebuttal, if that's okay.
Thank you.
It's been a little bit since I've been before court, so hopefully I'm not too rusty. I'm going to rest on my brief with regard to assignments of error 3 and 4, and I'm going to discuss assignments of error 1 and 2 sort of in conjunction with one another, since they sort of incorporate the best interest of the child analysis. With that said, I've laid out pretty clearly in Part A to assignment of error number 1 that the trial court's analysis did not really include any components that would pertain to a change in circumstances situation. I think the Gunner case is quite clear that that type of analysis is required, and absent it, I don't believe that the Court of Appeals can substitute its own analysis for the trial court. And on that alone, the case would have to be reversed and remanded.
Didn't he stipulate that there was a change of circumstance though?
No, opposing counsel incorporated into their brief that the timeline is this. There was this slight misnaming in opposing counsel's brief. There was a motion filed in October of 17 seeking to change, I believe it was companionship and the medical insurance. This matter was set for a hearing in April of 18, and I filed a motion on behalf of my client, a motion to change the parental rights and responsibilities, and argued that there could be a change of circumstances. Opposing counsel pointed out that that would be tantamount to a stipulation, and it is not, for a couple of reasons. Number one, contemporaneous with that motion being filed, I filed a very descriptive motion to continue. And in that motion to continue, I laid out that that motion to change parental rights and responsibilities was only filed because the child had started with a new counselor in January of 18, and that all the parties, including the guardian ad litem, agreed that the child needed more time with her counselor before we could really put any stock into how the child was performing during that time period. The second issue, of course, is whether I allege it and the other party alleges it, the basis for our change in circumstances are rooted in two different factual assertions. It's not incumbent upon us to make those findings of facts. Just because I asserted it doesn't mean it was to be found true, and in fact it wasn't, because the trial court ruled against me. So with regard to the two assertions made by opposing counsel as to why that issue is moved, those would be my two responses, and in fact it is not. To the second component, Your Honor, and let me add one more point, I'm sorry. Opposing counsel, I believe, leveled an argument that I did not object to the trial judge when I filed my objections to the magistrate's decisions, that there was no analysis with regard to change of circumstances. When you read my brief, what is very evident is that there's only one scenario under the statute where the court could have even analyzed a change of circumstances, and it is the component that is that a change would be in the best interest of the child, and that change would outweigh any detriment to the child. My objections to the judge were all about that. They were all about the best interest. They were all about the magistrate's analysis being devoid of any factual findings on which they could find that their decision was rooted in the best interest. And so, to opposing counsel's argument, what I submitted to the judge, whether it was captioned that way or not, is definitionally within, I am definitionally arguing that a change of circumstances analysis did not take place, because the only change of circumstances analysis that could have applied was one in which was based on best interest of the child. And so I think that's a very significant point to highlight. To the second issue, or assignment of errors, to subsection B of assignment of error number 1, I assume that this court might find that a change of circumstances analysis for one reason or another might not be warranted, or that in fact you could substitute your own analysis for the trial court. And I argue quite adamantly that the facts that were found by the magistrate and the judge, when counted together, are shorter than my brief alone, and also shorter than opposing counsel's brief. And when I made that argument, it frustrates me. And I find myself getting angry, and I try not to, because we as lawyers are supposed to be objective. And the reason why I'm angry or frustrated or saddened by it is because we're talking about people's children. We're talking about a child who is effectively being removed from her father's continual and constant contact. And that's startling to me, because if you're going to do that, I feel that there's an obligation that you do in your analysis a thorough job of explaining why you're reaching the conclusion you are. And I don't think the trial court did that. And the caveat would be, I don't think I would say they rarely ever do that, which is even more troubling to me. Which is part of what I argued in that same subsection of assignment error 1, which is that the family courts, and I'll say in this country, in particular, I'll keep it specific to Ohio, have deviated greatly, in my opinion, from what would constitute an appropriate best interest analysis. And they have focused on the relationships between two legal guardians, and I use that two parents, two adoptive parents, whatever it is, biological otherwise. And it frustrates me, because the articles I cited clearly state that that's not in the child's best interest. That regardless of the interaction between the parents, it is better for a child when that child has exposure to each parent that is akin or close to equal time. I believe the threshold number that's cited within those studies is about 35%. And when I look at the standard order that's before, that's currently enacted by this court, not this court, I'm sorry, the Summit County Domestic Relations, and you do the math, on a monthly basis, the standard order would give a non-residential parent 108 hours a month. There's approximately 700 and some odd hours in a month on a 30-day month. That means a parent who is not a resident that is receiving the standard order, at least on a regular basis, is seeing their child 15% of the time. That's appalling to me. I become emotional every time I think about it.
Does that include sleeping time and school time too?
Yes, Your Honor, because the standard order is every other weekend, and I believe it's 3 hours on a Wednesday. And obviously, I'm aware that some of the members of this court have been practitioners in family law, and can, probably from your own experience, realize from the fact that, as a practical matter, children as they get older start to have more events, more activities, and those Wednesdays nights even start to disappear. And because of the current situation or structure that we have in these family courts, or in particular Summit County Family Court, it doesn't allow flexibility for those situations, unless the parents agree. And I cited two opinion issued by the trial court judge. I don't know if it made it into the appendix or not. I know there were some issues with regard to it maybe being stricken, I don't know. But the reality is that a trial court judge in family court wrote an op-ed piece stating inaccurately that shared parenting is increasing. And he was responding to an article in which was discussing a totally different situation, which is in situations where parents don't agree, shared parenting is almost never given. And that doesn't benefit the child. That may benefit one parent versus another, but that's not what the law dictates. That's not what the law is required to look at. And for all the other reasons I stated in that subsection to assignment error number 1, subsection B, those are grounds at least particular to this case, while the best interest standard was not met. But if you get through assignment of error 1A and get to assignment error 1B, I implore this court to consider finding that the standard order that's currently being administered and put into effect by the Summit County Domestic Relations Court does not comport at all with what we should be requiring the standard to be for the best interest of a child. Thank you.
Good afternoon. May it please the court. My name is Attorney Chandra Muster, and I'm here on behalf of the appellee, Mother Candy Herron, to address Mr. Herron's assignment of errors. I know the first one directly hinges on whether or not change of circumstances needed to be found, whether that argument was waived by Mr. Herron, or whether the court did in fact find the change of circumstances. As I first argued, Your Honor, I believe that Mr. Herron waived his right to assert an error with regards to an allegation that a change of circumstances needed to be made. I do agree that in this case, with the way the schedule was changed, Gunderman does say that there should be a change of circumstances.
There was no designation in the initial divorce decree as to who was the residential parent for school purposes, though. They were leaving that for another day, correct?
Yes, you're right, Your Honor. At the time, there was not a designation of residential parent for school purposes. However, the parties did have a week-on, week-off schedule, and so the time was primarily 50-50. They did keep that shared parenting, but did give the vast majority of the time to the mother, Mrs. Herron. And I do believe from the reading in Gunderman that that change in time meant that she would have far greater say in the child's normal life and those normal decisions, and may need a change of circumstances. I would first assert, Your Honors, that in filing that motion, I understand it was submitted in line with the motion for continuance, but there are two ways in which a modification could be sought. Mr. Herron could have sought a modification of terms pursuant to Revised Code 3109.04E2B, which would have just essentially said a change in the best interest. Instead, his motion specifically indicated that a change of circumstances pursuant to 3109.04E1A has occurred since June 28, 2017, and a reallocation of parental rights would be in the best interest of the child. If Your Honors do not find that that waiver is applicable, I still believe that this court did address and find, or the trial court, I'm sorry, did find that change of circumstances. Because the issue was never raised directly before it, I do not believe it's reversible error that the trial court did not say the change of circumstances is blank. That issue was never brought before either the magistrate or to the trial judge on the objections. However, if the court...
Let me ask you a question.
Yes.
Why would, put aside the objections for
Yes.
a second, but with the magistrate, why would that have to be brought in front of the magistrate? Wouldn't that be something the magistrate has to look at as a matter of law?
I think she would. You're right. I think in our case, both counsel had indicated that the change of circumstances had been made. And in fact, in my initial questioning of the mother during direct, we did address the changes. And in fact, the magistrate in her decisions does cite to those changes of circumstance.
The reason I'm getting at this point
I'm
is,
sorry.
no, that's okay. The reason I'm getting to this point is, I want to make sure I understand what your argument is. Are you arguing that the parties themselves can concede there's a change of circumstances and the court has to go along with that?
I think if the court doesn't believe there's a change of circumstances, the court does have to make that finding. It's right there in the statute that a change of circumstances. So no, I think if the court itself believes that a change has not occurred, then that magistrate should indicate in their decision and should evaluate that. And I think she did here in her, let's see, if I look at her magistrate's decision, which would be on page 8, she indicates the parties do not communicate in an effective, constructive manner. Extreme example is the father's total silence when he changed the doctors. That did occur prior to the new motion being filed. We had an agreed judgment entry June 28, 2017. Mother filed for her modification on October 20, 2017. Before October 20, 2017, father utilized his primary insurance status to change all of the child's doctors. The pediatricians stopped her counselor. She had been seeing Miss Kelsey Sween since March of 2016, and father unilaterally stopped that, even after mother offered to pay out of her own pocket if it wasn't covered. And then we do go back, and the magistrate also notes in her order that the child was found later to have been being sexually abused by her paternal grandfather. And so the stop of one counselor and a significant period of time left before that child started again, we very well could have learned of the sexual abuse earlier. Unfortunately, we'll never know. But that also occurred prior to the new motion. And the magistrate does cite those changes that occurred in her decision. So I believe that the magistrate did look at what changed since the last court order and indicated the changes of the doctors, the canceling of the counseling, the fact that we have now learned of the child's sexual abuse, and then goes on to indicate that she believes that after that change, that this modification was in the child's best interest, to modify it to mother having the vast majority of the time and father having standard order.
But she didn't terminate shared parenting.
She did not terminate shared parenting. She did keep that shared parenting plan in effect. And I agree and understand Mr. Herron's argument about the amount of time to be spent with each parent and that a child's relationship with each parent is beneficial. However, Your Honor, I think we have to look at the facts of each case. And in this case, Mr. Herron used his time on a week on, week off to deny this child access to her mother for 3 straight weeks. Not just, and I do say it right, denied her access to her mother. Not even a phone call in 3 weeks. This child who is well behaved and does well in school was acting out in school, was getting yellow colors sent home, had hit another student. Mr. Herron knew of this stuff while this was going on, and even while he's watching how his child's behaving, he still refuses to even reach out to mother. Mr. Herron, again, just took this child's counselor away from her, this person that you build trust with, and took that away. And until a satisfactory counselor was reached between the two parties again, did she get to start into that. We also ran into a situation because of his refusal to communicate with mother what he was going on. This child was almost double immunized. He had had the child immunized by one doctor to whom he never provided her information to mother. And then when mother reached out to father and indicated she was going to seek the immunizations, only then did she find out that the child had been immunized, and then found out that the child had been switched doctors, and it still took additional time to find out where. So unfortunately, in this case, Your Honor, I don't believe that Mr. Herron was utilizing his time in the best interest of the child. She had many problematic things happen to her, a lot of switching around. And she is settled, and this new order could provide her some stability and allow for consistent changes to be made with the parent that did continue to communicate, that did reach out regardless of how communication was made towards her. And I believe that the court found the change of circumstances and did make an order that was in the best interest of the child. Thank you, Your Honors.
Counsel, you see you just have a little less than time.
Yes. I just want to step up preliminarily.
That's fine.
first point that stuck out to me was the assumption that, well, in general, it's this abuse of the child. Obviously, nobody's here saying that the abuse of a child is something that we should brush aside and not pay attention to. What I thought that I articulated clearly, and I'm not sure if I did, but that abuse was disclosed about a week before this trial occurred. And when you read Magistrate Guy's opinion, there is a mention, but what does not appear to be reliance upon that issue. Because there was extensive discussion with the magistrate by the parties that it would be unfair to penalize either one of them for this situation, because neither one of them could control what it was that Mr. Herron's father did. Additionally, there was other facts, and I believe that they're sort of briefly mentioned in record, where the child made an allegation of abuse against mom's boyfriend in Christmas of 17. And so the abuse allegation and the idea that somehow not changing the counselor would have resulted in the disclosure to be sooner, I think is a gross misrepresentation of what the underlying facts would suggest. To the specifics of that counselor, and I put this in the brief, that the parties were supposed to mutually agree on what counselor the child would go to. And the record should reflect that they were unable to agree. And so mom, who was the insurer, unilaterally took the child to Kent Psychological. Father was trying to take the child to Emerge Counseling. At that point, they had different religious beliefs and philosophical beliefs on who was best to administer that care. The shared parenting plan, as I also cited too, very clearly stated that the doctors and counselors would have to change if the insurance changed and the former physicians or practitioners were no longer covered. That happened here. And I think what I articulated, no, I don't think, I articulated pretty clear in the brief that the trial court had some obligation at the time of the consent entry to discuss that, or at least to review it and determine that the parties were going to be able to effectively communicate and move forward, and that those gray area issues were addressed before they left court in June of 2017. That didn't happen. It's unfortunate. And I think Mr. Herron in his testimony acknowledged that he should have communicated better. I think he understands that. I even think Ms. Herron knows that she could have communicated better with him and then with each other as a whole. But that being said, the counselor Ken created some issues for Mr. Herron, the details of which are he had trouble getting records, they weren't speaking to him, they were only speaking to mother, and so when the insurance switched and the insurance no longer covered her, should he have been better about communicating that with her? Absolutely. I'm not here to say he shouldn't have. But the reality is that as early as January, I would submit that the child was seen, in my opinion, probably the best, if not one of the best, child counselors in the county, and if not Northeast Ohio, Cynthia Sauer. Somebody who was more than equipped, who had more experience than the individual at Kent Psychological to, I don't want to use the word administer, but I'm missing the word that I want, which is to counsel this young child through a very difficult relationship with her parents.
Counsel, it seems though like one of the things you're admitting that your client made some mistakes, and that's fine. We all make mistakes,
Sure.
but sometimes there are consequences for mistakes too. You know, that we can't, that we may be forgiven for, but we're not get out of, having to face the consequences. And isn't one of them that the judge really looked at the fact that for 3 weeks he wouldn't allow the child to see mom? How can that ever be in a child's best interest? And how do you ever guard against that as a judge when you have one parent that is interfering with a child's right to see the other parent, which is the reason for standard parenting to begin with, and with shared parenting? So the whole point is that both parents can be involved in the child's life because that's in the best interest of the child.
I think there's 2 points to that, Your Honor. Number one, factually, I disagree with how it was represented by opposing counsel. I think that Mr. Herron testified that he tried to make some phone calls. But what I would characterize as the child suffering from fits and throwing temper tantrums and having emotional problems during that time period, that's not accurate. The two teachers testified, Ms. Weatherby and Ms. Fraley, both of which remembered maybe one day in which the child had some issues, but for the duration of that 3 weeks was her normal, happy self.
Well, aside from that, I mean, because quite frankly, the first thing I thought of when I read that was, it was probably as a result of abuse, that she was throwing these tantrums and having uncharacteristic behavior. But regardless of that, the point is, whether she was like happy as a lark at not seeing mom, that's, the law regards it not in the best interest of the child unless there's something in that parent that makes them unfit or unable to take care of that child.
I think that, I don't know how else to address that answer other than to delve into the entirety of the facts, which is that each parent, the trial court.
And you have to finish up because I'm overtime.
No, I'm sorry.
You're overtime because of me, so I
I
apologize.
The relationship that each parent had with the kid, the behavior that each parent demonstrated, there was fault with it. And what I mean by that is when you look at the situations that Ms. Herron put the child in, they, at a minimum, created a situation that was equally detrimental to the child than that 3-week situation. And so these people had a tumultuous relationship in which there was such a fundamental lack of trust, and there was a fundamental lack of communication with one another that when we got Cynthia Salwan involved, those issues started resolving.
Counsel, we have to stop.
Yeah, no problem.
Thank you very much.
Thank you,
The court will take the matter under advisement and issue a written opinion that we sent to both sides. And also, we release on our court